Copyright disclaimer. Under Title 17 U.S.C. Section 107, allowance is made for fair use for purposes such as criticism, comment, news reporting, teaching, scholarship, and research. Fair use is permitted by copyright statute that might otherwise be infringing nonprofit, educational, or personal use tips the balance in favor of fair use. Okay, you guys. So I had to record this again. I think I'm going to leave my recording settings on the same setting all the time so I don't have to keep going through this. So my Gen X brain is trying to open itself up to the AI a little bit. So Tammy AI, at first I didn't like her, but I'm starting to like some of the stuff she comes up with. So I don't necessarily like the way AI vocabulary is. It's really weird, but I'm going to just go with it anyways. Explosive revelations in Scientology lawsuit, new star witness emerges. I'm going to go ahead and have Aaron on here so you guys can hear him.
Parte hearings referred to as emergency hearings for that reason. The plaintiff's attorneys have asked for an ex parte hearing that is on the schedule for tomorrow to allow this new bombshell witness to weigh in with an affidavit regarding Scientology's internal arbitration process and the contracts that Scientology has all of its members sign to force them into internal religious arbitration. There's a bit to understand about this. I'm just going to go one little step at a time here. Wait, I got to check something on YouTube. No, we're fine on that. Okay, so let me show you some stuff here. Let's just see what they have to say. The reason this was an emergency, the reason they had to request this emergency hearing on Monday is because up until Friday, there was a hearing scheduled on Tuesday about the enforceability of the arbitration contracts. And that's why this new witness, they were trying to get them admitted on Monday. Now, the hearing on Tuesday has now been postponed for completely unrelated matters to this new witness. And I'm just going to walk you through both of these issues. But first, let's look at the ex parte application. We're not going to read the whole thing, but there are certain sections I want to share with you. Okay, statement of facts. Plaintiff's opposition to the motion to compel arbitration requires, in great part, discussion of matters typically shrouded in secrecy by defendants. Now, guys, remember, defendants, generally speaking, is just Scientology. So I'm going to say Scientology instead of defendants. Scientology have submitted numerous affidavits by witnesses associated with Scientology, the Scientology organization, in support of their motion to compel arbitration. Despite diligent efforts by plaintiffs to find witnesses willing to provide information during the discovery process and otherwise to support her claims, no direct witness to the events Jane Doe complains of was available to submit an affidavit in support of her opposition to the motion to compel arbitration until the current witness came forward. On the evening of March 20th, 2024, plaintiff had a discussion with the potential witness who shared for the first time information that would be pertinent to this court's ability to ascertain the truth of the facts asserted by Scientology in the motion to compel arbitration. Today, on March 21st, 2024, that potential witness for the first time committed to a willingness to submit an affidavit in support of Jane Doe's opposition to the motion to compel arbitration. Without the ability to submit this key testimony to the court, plaintiff will suffer irreparable harm. She will be unable to provide this court with a full set of facts upon which the court may decide as to whether to relinquish jurisdiction over this matter in favor of Scientology arbitration. And then my understanding of the next section of this filing is them basically saying they have not yet requested such an ex parte application for a matter such as this yet in the case, and therefore it should be considered. Super interesting. Okay, now let's look in why it's not as troubling as it might seem with respect to the ex parte motion for this new bombshell witness. Okay, the judge's order. The court orders that 1, the hearing on Scientology's motion to compel arbitration and the case management conference are continued from March 26th to April 16th. And this is the paragraph that got my panties in a bunch. The court orders that the briefing and evidence presented in connection with the motion to compel arbitration has been completed and is now closed. The court therefore orders that the parties shall not file any additional evidence, briefing, or papers in connection with the motion to compel arbitration. Oopsie. Taken in a vacuum, that last paragraph of the judge's order could be interpreted to be rejecting and throwing out the ex parte motion to admit this brand new bombshell witness. As of right now, we know that it is in fact not. This ruling was made independent of the ex parte motion. And this language that the judge uses, this last paragraph here, the court orders, that is something he has already previously said in his rulings prior to this current ex parte motion to admit this new witness. This was just a reiteration of language he had already used in his prior rulings, which is why the ex parte motion is actually just asking the judge to reconsider what he had already said about no more witnesses, no more evidence. Now, is it possible that both parties, the plaintiff's team, Scientology's team, shows up to court tomorrow, 8:30 a.m., and the judge says, yeah, I know this was still on the schedule, but that ruling that I said, we're adjourned, we're not doing this hearing. Is that possible? Yes, that's possible. But as of right now, I've been able to verify that both teams are scheduled to show up in court tomorrow. That hearing is still on the schedule. The judge's published ruling did not invalidate or throw out that hearing. That hearing has not been continued or canceled. It is on the schedule. So I'll be able to let you guys know what happens at that hearing tomorrow. And this star witness entering in at this stage in the case should make Scientology very, very afraid. And I'm really hoping, I mean, guys, I've made the mistake of getting very, very optimistic in the ways that judges rule in these civil lawsuits against Scientology. It has been mind-boggling and soul-crushing to see judges seem to telegraph that they're going to rule in the plaintiff's favor on various motions and appeals and all this kind of stuff, only for them to come back and just completely rule in Scientology's favor because their hands are tied because of case law and all this kind of stuff. Or, what is it? Is it case law? No, what is it? Whatever, you guys know what I mean. I am optimistic about what's going to happen at tomorrow's hearing. But I don't know how much that optimism is worth. I'm just saying it for the record. Okay, so let's see. What else? Is there anything else we need to cover in this video? I really don't think so. That's it. Oh, what lawsuit is it again? Someone's asking. This is the Jane Doe lawsuit. This is the Jane Doe lawsuit to
I definitely understand what he's saying.
allow this new...
I understand what he's saying. You get your hopes up and then they just screw you. Victims always go through it. So I'm going to read this. The Scientology lawsuit involving allegations of institutionalized child abuse has taken a dramatic turn with the introduction of a bombshell witness. The witness's testimony could be crucial in the case against key figures and organizations within Scientology. Yeah, if the judge allows it. You see what I mean? Emergency hearing and witness testimony. Plaintiff's attorneys filed a motion for an emergency hearing to introduce a bombshell witness. And guess what, Scientology? More witnesses are coming. More witnesses are coming. Sucks for you, doesn't it? The new witness committed to providing crucial testimony. Well, let's see. Maybe I don't really know if I want to go over everything Aaron said. This just kind of gives you the gist. Arbitration hearing and evidence submission. Arbitration hearing and case management conferences postponed to April 16th, 2024. So this is kind of old news. Judge's order seemingly closes evidence submission for arbitration motion. See, in the child sex abuse, these arbitrations are getting locked down.
Doesn't that fucking suck for you, Scientology? All in there raping all those children and you thought you could get away with it.
The lawsuit pertains to child sex abuse and Scientology's attempt to divert it, no, to thwart it, to religious arbitration. So let's see what else here. Why did the court order Scientology to amend their application to seal? The court wanted transparency, opted for certain exhibits to be part of the public record. So I'm not going to read the whole thing, you guys. You guys can read it. It kind of covers what Aaron was talking about. But it does have some good stuff here. And especially I like how they have the timestamps. So they have timestamps in there if you want to go back and look. I will leave a link in the description box. Like and subscribe if you choose. Otherwise, have an amazing day or night. Thank you.